the question is, can she take the kids that belong to Oregon, that we live in Oregon, to another state and file for a divorce and for custody, knowing that I can't make it and I won't be able to get out there in time?
Okay, the answer. We're back. This is Attorney Vince Davis. This is The Secret, How to Fight CPS Win. I'm joined by my co-host, Amanda Cisco. And we might have Erin Carranza, might not. She was having some technical difficulties. But ladies, we're going to take another call. David from Oregon. David, did you have a story to tell or a question to ask?
A little bit of both, I guess you could say. I have a question.
Hold on, David. David, hold on a second. Where are you? What county are you in Oregon?
In Seaside.
Seaside. Where is that in relationship to Deschutes County?
Nothing to Deschutes County, no.
Is it close to Deschutes County?
I have no clue, sir.
Okay. Go ahead. Tell us your story and then ask us your question.
Well, my wife left Oregon and went to California, and she has my 4 children out there. We were making peace. She does this all the time. She puts restraining orders. She has ran from Iowa. I've been to like 4 different states, and all the states that we've been in, she's once a month will put a restraining order. Not to put it that bad, but there's restraining orders all over, but she never complies with them. She never goes in. So she's been lying about these things. Now she went to California. She went to the courthouse, put a restraining order on me again, and I'm in Oregon. Nothing happened. Within this time that the restraining order that she had put in, she's calling me. She's making peace with me. Then all of a sudden, 2 to 3 days ago, again, she called me in the morning, said she wants a divorce. So then she goes to the courthouse. She puts a 3-day emergency court order for me to go down to California by Monday and claim my kids. That she wants to take the kids and she wants a divorce and the whole thing. So the question is, can she take the kids that belong to Oregon, that we live in Oregon, to another state and file for a divorce and for custody, knowing that I can't make it and I won't be able to get out there in time?
Okay, the answer is yes, and that's just proven by the fact that she did it already. The question becomes, though, can you get the case transferred to Oregon? Because you may not have any what they call constitutional minimum contacts with the state of California, or it would be unfair to have the case in California. She moved, she went to California. So there are a lot of jurisdictional issues that, come up. If you just appear in California without challenging jurisdiction, or if you challenge jurisdiction, but you also challenge something else like visitation, you will have waived that jurisdictional argument and you'll be stuck fighting that case in California. So what you might want to do is contact a California lawyer and find out if there is any defense that you can put forth, jurisdictional defense, where you can have the case sent back to
Since I have
Oregon.
a question, could he file a counterclaim in his jurisdiction using the long arm statute, or would that not apply to this? I learned this in my paralegal classes. We covered this a couple weeks ago.
No.
Okay.
Is
the case that your wife filed, is it in the family law department of the California?
Yes, it is. It's in divorce. It's it's in family court.
Do you know what county?
In Pomona. I'm sorry. Yes, in Pomona.
Oh, that's way down in Southern California by me.
Yes. And that's what I'm saying, that how would I make it? What was asked for me to do, or by another lawyer that I spoke to, he said, you have to write a letter and I have to notarize it and I have to submit it before the court date, so the judge now can look it over and see what my story is, and then he'll go upon making a decision, knowing that I can't make it because I'm in Oregon.
Well,
with that being said, the letter. Yes.
If you do that, all right, And by the way, you can appear these days in Pomona via web call, so you can appear on the phone or on a web
Oh,
cam.
okay.
But what I'm telling you, if you appear and you don't make what's called a special appearance, you are going to be stuck in a California court. What you need to do is you need to make an appearance to specially appear to challenge the jurisdiction of the court over you. And you should talk to a California attorney about that. Okay.
And they wouldn't help me. I was looking, and I've been calling all day, and this is like, I've been on the phone all day and since yesterday, since she sent me these emails saying, oh, you have to be here in 3 days, or I'm taking 70-30. She's trying to send my boy that's 6 years old, and she's trying to keep my 3 little girls over there separate now. But then another thing is that
when you say you've been on the phone all day, today's Saturday, who were you on the phone with?
Well, I was talking to lawyers and talking to family members and trying to see what I was going to do. But like, my question is to you, what can I do with this? With that, so you're saying I have to. I'm just confused with everything. How she's able to do that and then leave me out here hanging like if I'm the bad guy and I can't do anything about it unless I get that thing that you said, right?
Okay, so here's something. I don't know if you heard the last caller, but Amanda gave some really good advice to the last caller. You got to focus on your case, not on your problems with your ex-wife or your wife or the mother of your children. You're getting them all confused, and they're separate. What I would do is I would find a lawyer in the Pomona area that does family law and tell him or her that you want to challenge personal jurisdiction. Okay. And they will know exactly what they should do or what you should do.
Yes. And so then, but this is due for Monday. There's no way I'm going to be able to get all that done Monday morning before I have to present myself in court, she said, right?
Right. Well, has she served you with paperwork? Because they can't.
No, sir. She gave me a phone call.
They can't proceed until you've been personally served with the paperwork. So
I called the courthouse and they said that there was no records of me having to present myself on Monday, but she sent me emails and she said, you better get ready. Her mother told me, oh, you better get ready because she knows the system. So with that being said, I thought it was serious. And maybe like you're saying, no, I haven't received any papers to show up at court, an email, nothing. But she stated in an email saying that I needed to be there on Monday or else they're going to give her 70% of the children and then we're going to send only one down to Oregon. So you're saying that if I don't have no papers and no courthouse, there's no way I need to be in court on Monday, right?
Right. If you weren't served, you don't have to be present. Or you can appear and say, Your Honor, I specially appear. I'm going to be getting an attorney to challenge personal jurisdiction. But
also don't give people power that they don't have. You know, I heard that you mentioned she knows the system and she's going to take 70% and Don't give people the power that they don't have. Don't let them intimidate you. This is a theme that I've seen in my case and so many cases. You know, they're just trying to get you worked up. Take a deep breath.
The mother telling me this because the mother, because she has another two sets of other children with two exes of two other marriages that her mother has raised. And so her mother's telling me, I don't want to raise your kids. Come get your kids, David. And I'm like, well, I'm trying to, but so Jessica's holding the kids down at the house. Now she has 3 sets of kids that her mother, and her mother's telling me, come pick them up. So at the same time, she's the one that's telling me she knows the system. She's done it before. So you better be careful. And that's her mother telling me.
Don't let her intimidate you. It's up to the judge and it's up to the laws and the.
Hello?
Yes, I'm here.
No, I'm sorry. It cut off sort of, but yeah, that's the situation that I'm in. And okay, well then I see what I need to do is that what you said to get that jurisdiction thing, and go from there, right?
Yes, David. Listen, I want to thank you for calling and thank you for listening, and good luck in court on Monday.
Thank you so much.
All righty.
Thank you, sir.
Bye-bye. David didn't have a CPS case. He has a family law case.
Oh. Sometimes I wonder to myself, Vince, what's the difference really? They both place you in
2 minutes.
Either way.
Oh, there's a substantial difference. In California, at least, CPS's case is governed by the Welfare and Institutions Code, and family law cases are governed by the Family Code. Different sets of laws, different tests, different burdens of proof. So they're substantially different. I mean, to most non-attorneys, you know what they are? They are just cases about kids and parents, right? But that's all they have. That's all they have in common.
I want to ask you a question.
Mm-hmm.
There's 2 judges. They do CPS, child support, family court. They do it all. We're stuck. We have nobody to turn to. There's 2 judges.
What state are you in?
Yeah, I'm Virginia. I'm in Winchester.
Okay. Well, I don't know the laws in Virginia. I'm only licensed in California. So, but if you're in California, I can tell you that, even if it's the same judge, they have to apply different laws. So there are some counties in California where they're small counties. They don't have 20 courthouses and 300 judges like Los Angeles. They might have 1 courthouse and 3 judges or something like that, and they do everything. They do all types of cases. So you just have to work with what you have. And generally speaking, family law cases are different from CPS cases. Hey, the engineer is telling me we've got to take another break. This is The Secret, How to Fight CPS and Win. We'll be right back after these messages.